Good morning and welcome to this strategic licensing webinar, which is aimed at developers, landlords and landowners, and will hopefully give you an insight into some of the licensing considerations and the ways in which the licensing team may be able to assist you with maximising and protecting your leisure units and assets. There'll be three of us speaking today. I'm Felicity. I'm a partner at Kuits and head up the licensing team. I'm joined by Becky, a senior associate in the licensing team, and Charlie, a solicitor in our commercial property team. Becky and I are part of a larger licensing team who deal with all things licensing for a wide variety of clients, from bars, restaurants to event spaces, cinemas, theatres, sports stadia, and indeed landlords and developers. Anywhere that alcohol is sold or provided, we're involved. We're the only licensing team in the Northwest ranked in the top tier of the Legal 500. Between us, we have many years of expertise in this field. One key message we'd like you to take away from today is that we're always at the end of a phone. If you ever have, excuse me, any queries or anything you'd like to discuss in relation to any licensed properties or assets that you might have, then we're always happy to have an initial call. So please just pick up the phone. These are some of the clients that we are lucky to act for, some household names there. And yeah, we're fortunate to act for a wide range of operators within the hospitality and leisure space. So let's get started. This is the agenda. These are the topics that we'll be covering today. Premises licenses, what they are and when they're needed. Conditionality in leases for leisure units, provisional statements and provisional licenses and the differences between the two, activating the public realm, the use of shadow licenses, Section 178 notices, reviews, the lapse of licenses, and Charlie will speak at the end regarding planning permission. And if we have any time, we'll take some questions. So Becky's going to start things off by covering some licensing basics.
Thanks, Felicity. Morning, everybody. I'm just going to start with talking about the Licensing Act 2003. Most of the work that we do is governed by the Licensing Act, and largely what we're looking to do in most of our day-to-day work is to obtain or preserve premises licenses for operators. A premises license permits what we call licensable activities to be carried out at any given premises. And as per the slide, there are three categories of licensable activities that are relevant. The first is the sale of alcohol, which is either for consumption on or off the premises or both. So on the premises as in a restaurant or a bar, or off the premises as in a supermarket or an off license. There's then the provision of regulated entertainment, which covers all of the categories that you'll see on the slide there. And the provision of late night refreshment, which is the sale of hot food or hot drink between the hours of 11 p.m. and 5 a.m. So this would cover hot food takeaways, for example. And the Licensing Act brought late night refreshment under the same legislation as the sale of alcohol and regulated entertainment as part of an acknowledgement that late night refreshment venues tend to form part of sort of the late night economy. So any premises which carries out any single one of these activities, so not necessarily the sale of alcohol, any premises that carries out any one of the regulated entertainment or just late night refreshment on its own, requires a premises license. A license will be held by a specified entity from time to time. It's usually a company, but can also be an individual. But the license is particular to the unit itself. And a key basis of the licensing regime is the ability of the local authority to decide what's appropriate and acceptable in any particular locality. So the license attaches to the unit itself. And once granted, it lasts in perpetuity unless it is revoked, lapses, or is surrendered. And there'll be more on those various terms later. However, a license can be transferred from entity to entity with relative ease. So whilst it stays attached to the particular unit or space that's licensed, an operator of a given unit can change from time to time relatively easily, but continue to benefit from the same premises license. When we're applying for a premises license on behalf of any client, we specify the activities that the operator wishes to carry out and the hours that they wish to trade those activities. We then propose conditions that should be attached to that license if granted, and our aim here is to add appropriate conditions that the authorities would expect to see and therefore try to avoid any objections to license applications, but also not to offer up anything that would be too onerous to the particular operator of the unit. Each condition attached to any license has the aim of upholding one or more of the licensing objectives, which you can see there on the screen. And these 4 licensing objectives are the main pillars of the Licensing Act 2003. So any operator should be looking to uphold those licensing objectives in the way in which they operate. An application for a premises license goes to the local council in the area in which the unit is situated, and the responsible authorities are consulted on the application. Responsible authorities include bodies like the police, environmental health, the fire safety team, and the planning team, for example. The application also needs to be advertised on the premises itself and in the local press. And once the application goes in, that triggers the start of a 28-day consultation period in which objections to an application can be received. These can come from the responsible authorities or come from any interested party, such as local residents or other nearby businesses. In the absence of any objections, a premises license is granted immediately following the end of the 28-day consultation period. If objections are received, then our role is to try and negotiate those objections away on behalf of the operator. But if that is not possible, a hearing is convened in front of a panel of local councillors to determine the application, whether the license should be granted or the application be refused. That hearing should be held within 4 weeks of the end of the 28-day consultation period.
Thanks, Becky. So conditionality, as you can see, and as you've heard from Becky, the process to obtain a premises licence can be fairly drawn out. And of course, having a licence in place is an absolute must for any tenant operator who wishes to carry out a business involving any licensable activities. As such, it's usual for agreements for lease on leisure units to be conditional, amongst other things, on the grant of a satisfactory premises licence. This will often be defined as a licence free from onerous conditions. For example, a nightclub operator would not be satisfied with a licence that terminates at 10 p.m. daily, and a small cafe bar operator wouldn't be satisfied with a licence that required them to have 5 members of professional door staff on every day, for example. So as such, operators will usually want a licence in place before they will complete any lease. This is even more likely to be the case in locations where there are what is known cumulative impact zones. A policy such as that makes obtaining a licence much more challenging. They are areas that local authorities identify as being particularly problematic, particularly in the nighttime economy, due to the concentration of licensed premises, areas where there's a prevalence of crime and disorder and antisocial behaviour related to alcohol and entertainment. Authorities have the option to designate such areas as CIZs, and these create a rebuttable presumption against the grant of new licences in the area. These can be overcome more easily in some areas than others, but the applications have to be approached very carefully, and the onus is on the applicant or us on their behalf to demonstrate that they won't add to the issues already being experienced in the area. As such, there's a real risk of refusal if tenants don't have the right advice, and tenants will of course not be willing to risk signing up for years-long leases if there's a risk that they can't trade the premises. Conditionality will likely be even more important from a tenant's perspective in these areas. But there are ways around this, or ways we can assist with this, and Becky will discuss those now.
Thank you. Yeah, so the first mechanism to be aware of here in terms of applying for licenses or looking to establish license uses on behalf of landlords or developers is provisional statements. These are best described really as pre-license applications, and they're a way of providing the applicant with an indication of what the likely response would be were they to go ahead in the future and apply for a full premises license. They're best used when there is no clear proposal as yet as to what a unit or a site might look like, but there's a general concept that licensed use might be desirable in the particular vicinity. An application for a provisional statement like a premises license is made to the local authority, and it is advertised like a premises license. But as I say, there's no need to provide a clear plan showing exactly how the unit or the space will be laid out. So it can be done more easily before plans for any particular space are crystallised. If granted, it does give a really good starting point for future license applications, because what it does is it prohibits anybody who could have objected at the time of the provisional statement application from objecting to any future application for a premises license, provided that the application for the license is on the same terms as the provisional statement, so the same sort of hours and the same activities, etc. So these can be really, really useful tools for rooting out potential issues with licensing a particular unit before any specific investment or any more detailed plans are made in respect of any particular development. So if an application for a provisional statement is put in and receives objections from hundreds of local residents, that gives a really clear indication that there might be a battle on any operator's hands to obtain a premises license in that area. However, the disadvantages of this approach is that there is still the need to make an application for a premises license. So this won't help to remove any of the conditionality in agreement for leases that Felicity mentioned. Additionally, the protection that a provisional statement provides does dwindle over time. So in terms of defending against prospective objectors to a premises license application, the protection becomes less and less as time goes on. As I mentioned, a provisional statement bars anybody who could have made an objection to a provisional statement application making an objection to a later premises license application. But if the area has changed significantly, for example, new residents have moved into the area since the provisional statement application, then those residents, those newcomers to the area would still be free to object to a premises license as they usually would. However, a step up from the provisional statement process, and particularly where there are more detailed plans for an operation, is going down the route of what we like to call provisional licenses. And Felicity will discuss those now.
Thanks, Becky. Yes, provisional licenses are a step up from a provisional statement, and they're more useful because they are premises licenses. They're full premises licenses, and we've had a degree of success over the last few years convincing local authorities up and down the country that an application for a provisional statement isn't necessary, and operators, developers have been able to go straight to a provisional premises license to cut out that additional step. They can only be applied for, though, where there's a bit more certainty. So in a development, for example, matters will have progressed to a state that there's an ability to demonstrate the particular units that are going to be licensed, and there'll be loose layout plans available that can be provided as part of the application process. It doesn't matter if those layout plans aren't final or if they change during the course of the development and the course of construction, but there just needs to be a bit more detail there, a bit more of a solid intent than we might want to license something here. In these circumstances, we'd simply apply for a premises license or premises licenses on behalf of the landlord or developer as soon as those plans can be produced. As Becky mentioned, licenses can be transferred from entity to entity through a short application that takes immediate effect. And so what we've done over recent years is we've applied for licenses in the name of a developer or landlord. to the sorts of hours with the sorts of activities that would be acceptable to their target tenant base. And then once the tenant is secured, the license can simply be transferred to that tenant. And that has a number of advantages. The unit can be marketed as licensed from the outset. The conditionality that I discussed previously can be removed because the tenant doesn't need to obtain their own license, and the developer can retain control and uniformity across the estate. So if you want a good mix of restaurants open till midnight or so and don't want any nightclubs, that allows the landlord or developer to retain control of that rather than leaving individual tenants up to their own devices. And finally, by applying early, before a development is real and evident, particularly to local residents, is advantageous. A license for a concept has the tendency to be inherently less controversial than a license for a building that's been already constructed and where design and proximity can really be appreciated and visualised. And that's particularly the case for proposed mixed-use developments, as the propensity of people who've purchased flats above leisure units to object to license applications when those leisure units seek to become licensed will never cease to amaze us. You'd be surprised at the number of residents who appear shocked that the bar-shaped unit beneath their flats turns out to be a bar. As such, it's never a bad thing to get these licensed before the first resident moves in. And as I said, there's no sort of statutory time limit to when those applications can go in, and as long as there is an element of certainty and some loose layout plans, that's usually sufficient. And just by way of some recent examples that we've been involved in, London Road Fire Station and Circle Square, we applied for 10 and 12 licenses respectively for both of those developments long before any substantial building work started on either site. And as part of these applications, we were also able to assist with public realm activation and placemaking. And that brings me on to the next slide, which Becky will discuss.
Yeah, thank you. So yeah, as Felicity says, licensing can be a really valuable tool to assist in activating a public realm space. So premises licenses can't only be applied for in respect of internal spaces, but external spaces also. So licenses can be applied for on behalf of landlords to allow permanent or pop-up activations in internal common parts of buildings or in external public realm spaces. This is often really helpful to provide footfall driving activation at the start of a development, or to provide long-term sort of community-focused activities within a development, things like film nights or outdoor cinemas, pop-up food and drinks, traders, street food markets, that sort of thing. So to really start to try and create a bit of a sense of community in a new development, licensing can be a really, really important tool. We obtained a full public realm license for the Spinningfields development in Manchester many, many years ago. And this has allowed numerous pop-up events and activities over the years. So if you look at the license plan for the public realm license for Spinningfields, there's simply a red line which runs all the way around the Spinningfields development. So as you're walking, those of you familiar with Manchester, as you're walking through Spinningfields and you see any, a pop-up bar or a pop-up street food or whatever, that will be covered under this public realm license that, as I say, was obtained many years ago. And more recently, we've done the same with London Road and with Circle Square, as Felicity has mentioned, as well as, for example, Renneker's Deansgate Square development, which has public realm license for external space and also public licenses for some of the internal common parts that are available to tenants of the buildings.
Thanks, Becky. So that really covers the topics of applying for licenses where they don't already exist and how that can be done on behalf of landowners and developers. We want to talk now about how landlords can protect themselves from a licensing perspective once those licenses are in place. Licenses are extremely valuable assets, and a licensed unit without a license is, of course, a huge problem for a tenant, which can become a huge problem for a landlord. As such, one method of protection for a landlord is that where they have a licensed tenant who holds their own license, they can obtain what's called a shadow license, which they hold themselves. The term shadow license isn't a legal term. It's one that's been developed over the course of the last 20 years or so, since the Licensing Act 2003 came into play. But they are becoming more popular and more prevalent up and down the country. They are full premises licenses. The application process is exactly the same as it would be for an operator, but the terms of the application usually exactly match the terms of the license that is held by the tenant. So the hours, the types of licensable activities, and so on, the layout mirror those already licensed. So on the grant, what you have are two licenses, one being used by the tenant and one kept in the shadows and not used ordinarily. We'll talk about how a license can end up being revoked shortly, but that usually happens due to the misbehaviour or substandard operation by a tenant, and often the loss of a license will be capable of terminating the lease. And in those circumstances, a landlord may well want to get a new tenant in quickly, but without a license would struggle to do so, and that would cause some delays. And it's at that point that a shadow license comes into its own. The landlord can produce one that they made earlier and immediately transfer it to a new tenant operator. These are therefore most useful in our view where a licensed tenant runs a particularly risky operation, usually later night premises which are focused on the sale and consumption of alcohol. And that's where we see shadow licenses most usually, where perhaps a landlord is a little bit nervous about the future safe operation of their tenant, and so they get a shadow license in place for use if they need to going forward.
And then I'll just move on to just talk about Section 178 notices. These are a less intensive, less impactful, but still useful protection that landlords can obtain. They can be obtained much more easily and much more cheaply than a full shadow premises license. And these are, as I say, Section 178 notices. These are otherwise known as notices of interest, and they can be lodged by any entity with a legal interest in a licensed premises. What a Section 178 notice does is it requires the council to notify the holder of the notice of any applications that are made in respect of the premises license. So where a landlord has a tenant with a licensed unit, they can lodge a Section 178 notice with regards to that unit, and then the council will inform the landlord if the tenant tries to vary their license, tries to surrender it, tries to transfer it to another entity, or if a review application were bought in respect of a license, so that the landlord could then take action if they needed to. In terms of a review, I'll just whiz on to talk about what those are. So a review is, as it says here, the biggest threat to a licensed premises once granted. And therefore, from the point of view of a Section 178 notice, it's always useful for landlords to be aware of a review if one of their tenants becomes subject to one. An ordinary review can be bought by responsible authorities or other interested parties such as local residents if they believe that the operation of a premises is undermining the licensing objectives. So those objectives that we talked about at the start, so if the premises is causing crime and disorder, causing a public nuisance, impacting on public safety, or is in some way a danger to children, then an ordinary review can be bought. And what this application does is essentially calls the license back in front of the licensing committee for the licensing committee of the council to decide what to do with the license in light of the complaints that have been raised. And the options that the council have at this stage range from doing nothing at all right through to revoking the license. And there are various things in the middle. They can reduce hours, remove activities, suspend the license, etc. So an alternative type of review, is a summary review, This can only be brought by the police. This has the same result in terms of the long-term future of the licence being determined by a committee, but can also result in a premises being temporarily closed while the consultation period of the review runs. So that can often mean immediate closure for a licensed premises for a period of 3 to 4 weeks. So obviously this can be a review, whether ordinary or summary, can be existential for licensed operators, and therefore it's really important for landlords of licensed tenants to have an awareness of those issues and the risks, so that they can step in to protect their asset where necessary. So a Section 178 notice obviously allows them to be aware that this is taking place, to either assist the tenant with a defence of a review application if appropriate, or just to keep an eye on what's going on in case the licence should be revoked. And obviously a shadow licence can be useful here if the outcome of any review application in respect of a tenant is the revocation or suspension of the premises licence.
Licenses, however, aren't often lost by way of a review. The most common reason a license disappears is simply by its lapse. We see it an awful lot. A license can easily be transferred from one entity to another, but if an existing premises license holder ceases to exist, then the license lapses at that moment. So if a license is held in the name of a company and that company enters administration or is dissolved, then the license lapses at that point. On occasion, you see premises licenses held in the name of individuals, and if that individual were to die, again, the license would lapse at that point. And it lapses immediately, but it can be salvaged within 28 days if steps are taken to transfer the license into a solvent entity. If that's not done, it lapses permanently, and anyone wishing to trade the site would need to start again with a brand new license application. And as Becky outlined at the very beginning, that's a lengthy process. It can take anywhere, well, from a minimum of 1 month to up to 2 months, sometimes longer. And of course, there's no guarantee when applying for a new license that it will be reinstated or granted again. So there definitely needs to be a focus on ensuring that if a license is granted, it remains active. And if something happens to it, that prompt action is taken within those 28 days to make sure that it continues. As the slide says, a notification of interest, the Section 178 notice we were talking about, does not always help in this situation. That's because there's no reason for a council to be aware of a lapse. There's no reason that they would become aware of the insolvency of a licence holder unless it's specifically drawn to their attention. And if it is, that's often well beyond the 28-day period. So again, this is something that landlords should be alive to when it comes to preserving licensed assets across their site. Just keep an eye on its ongoing validity and take quick steps if it needs to be transferred onwards. So that's all Becky and I were going to discuss in relation to the licensing elements of this webinar. So I'm going to hand over to Charlie now to discuss a linked issue from a planning perspective.
Thanks. Yes, I just wanted to take a moment to talk about something other than licensing, and that was the planning permission side of things, because it is something that a landlord does need to be aware of. And a recent case from Manchester shows that specifically. So the facts of this matter are that P&M Property Investment Limited owned a property and they let it out to a tenant and thought nothing more of it. The tenant had correct planning permission in place to use it as a cafe, and the landlord regularly received the rents. The landlord thought nothing further until the tenant, without obtaining planning permission, changed the use of the cafe to a shisha bar. The council, Manchester City Council in this case, upon becoming aware of this breach of planning permission, issued an enforcement notice. And the enforcement notice was issued against the landlord and the tenant. So an enforcement notice attaches to the land rather than the person committing the breach. Now, neither the landlord nor the tenant took any action in relation to the enforcement notice. The tenant continued to use the premises as an unlawful shisha bar, and the landlord continued to receive the rents. The landlord thinking that this was the tenant's problem, and therefore the tenant's the one operational, the tenant is the one who is using it unlawfully as a shisha bar, it's the tenant who should be responsible. Well, that was not the case, and Manchester City Council eventually prosecuted the landlord for non-compliance with the enforcement notice. And at the hearing, the judge fined the landlord £18,750 and awarded a further costs award to the council of £5,700. So already the landlord is paying out more than £20,000 in fines for something that the tenant of its premises did. However, there is one further point to note in this. An enforcement notice, or rather failure to comply with an enforcement notice, is a criminal offence. And so the Manchester City Council decided to pursue the landlord under the Proceeds of Crime Act because it had committed a criminal offence and had made gains from the criminal activity. That argument was upheld, and rents amounting to £174,000, in excess of £174,000, were confiscated. So in this case, even though it was the tenant who had changed the use, the tenant who was doing the bad acts, the landlord ended up paying out over £200,000 in penalties, fines, and costs awards. So what are the implications of this for property owners and landlords? Well, the first thing to note is that enforcement notices relate to the land upon which the breach occurs, and therefore any inaction or action of a tenant can ultimately be the responsibility of the landlord. A landlord cannot simply rely on provisions in a lease to exempt itself from action, and that was the point specifically made in this case. It was found that the landlord took no action whatsoever, and what it should have done is taken action to force the tenant to stop using the shisha bar, to make it apply for planning permission, or to, return to the original permitted use. And ultimately, the landlord should have forfeited the lease if there was shown to be a regular failure to comply with the terms of the lease. Because the landlord had taken no action whatsoever, the landlord should be liable. And so for you as property owners and landlords, really need to develop a proactive monitoring scheme to ensure that your tenants are adhering to any planning compliance. Where a breach is identified, you should take the appropriate steps within the terms of your lease to ensure that you will not be held liable. So this will be ensuring that leases contain provisions requiring tenants to comply with all statutory legislation and other such laws, and ultimately have provisions in place to enable forfeiture of the lease in the event that there is non-compliance. And with that cautionary note, I will hand back.
Thanks, Charlie. So that was a whistle-stop tour through strategic licensing for property owners. We hope you found it useful. Thank you very much for attending. Our contact details are on the screen now. And as I said at the beginning, if you have any queries or you just want to chat something through, then any of us are more than happy to speak with you. So yeah, please do get in touch and enjoy the rest of your day. Thank you for coming.